All right, we'll have a panel switch now, and we will take a break after the next case and invite the attorneys to join us for coffee if you choose to. I'd like to welcome Judge Traver to the bench this morning. Morning, counsel.
Good morning, Your Honors. May it please the Court, my name is Moses DeWitt, and I represent the appellate EMORY SUMLIN in this matter. I would like to reserve 5 minutes for rebuttal. There is a multitude of errors in this dissolution of marriage proceeding. I'd like to start with the one that was error for the Court to require the former husband to secure a note and mortgage against the Windboard property, which we present was his homestead at the time, given the evidence of the Court. As this Court's well aware, Section 61.075, subsection 10, does allow a court to have a security interest to secure equitable distribution.
Well, we really don't know. I mean, the judge didn't make a finding. The issue really wasn't teed up as to whether it was homestead or not. Isn't that correct?
That's correct, because it was premature at that time, because what the court should have done here is put a lien on the property. And then if counsel tried to foreclose on that lien, then the homestead argument would be brought up. But here they're trying to circumvent that, because by signing a mortgage, it waives your homestead rights. It's very clear in Florida, if you sign a mortgage and they go to foreclose on that mortgage, you can't then say, this is my homestead, because you've waived it in that mortgage. So frankly, I think it's the way, typically it would have been brought up in the lien foreclosure lawsuit. However, here they were trying to get in front of that and basically prevent him from being able to raise that to the court, because obviously that's not something that normally is brought up in a divorce as to homestead protection and things of that nature, because it's not applicable in a divorce. But the evidence here is that he lived in the property since the case was filed in 2013, and the case concluded sometime June of 2018. As well as 61.075 subsection 10 really relates to equitable distribution payments. And here, there was a payment that the total amount was $32,000 something dollars, $18,084 was equitable distribution. The rest was basically attorney's fees that were then being wrapped into this mortgage that then, if he didn't pay, they could foreclose and essentially take his homestead. So we would submit that that was error. And frankly, I don't know that the court even has jurisdiction to force someone to sign a mortgage of any kind, let alone a dissolution of marriage proceeding. Courts certainly have lien rights, they have lien powers. And there's a section, Chapter 55 of the Florida statutes allows enforcement of those liens.
I mean, to the extent that the court wanted to create a lien, it could have just done so in the judgment.
Correct.
The judgment serve as the lien, and if they ever tried to foreclose, then determine whether it was homestead or not.
And I believe that would be the proper method to do that, just like you do with any other judgment, any other lien. But here, by forcing him to try to sign the mortgage, I believe that is where the court erred and overstepped their jurisdictional bounds. The next major error here, in my opinion, was the sanctions that were imposed by the trial court.
How many opportunities did the judge give your client to produce the requested information? And how many times did the judge say, if you don't produce it, I'm going to strike your pleadings?
So I believe there was a total of 3 hearings in this case. The major error started to compound after the February 1st hearing. My client did not attend that hearing. There was a hearing on February 1st. At that hearing,
there were at least 2 orders entered that said, I already told you to give it up, and if you don't, bad things are going to happen.
Correct. And those 2 orders, the first one I believe was the February 12th order. So the February 12th order was filed with the court on February 12th at 3:41 p.m. It gave my client till February 12th at 5 p.m. to produce the documents.
Laying that aside, wasn't the hearing held sometime earlier than that?
The hearing was held February 1st, and my client did not attend that hearing.
Okay, but that was his choice.
Theoretically, that was his choice, but
And in any event, even if the order was entered on February the 12th, he didn't try to comply on February the 13th, 14th, 15th, 16th, or any time thereafter.
Not to my knowledge. My knowledge is that, he did send some emails to counsel. However, by the time, the court's intent was to give him 10 days to comply. By the time he got that order, the deadline had already lapsed. And the court said...
Did he ever try to comply?
The record does not reflect that he did, that I'm aware of.
Okay. And yet there was another order after that.
So then there was the April order, which was April 5th. The wife filed a motion for pretrial matters and then set that motion 5 days later on April 10th for a short matters hearing, where basically they had the judge sign the order, entering their sanctions against him and striking his pleadings. That order was emailed, or the motion and the notice of hearing were emailed to him. At that time, under the mail rule, it wouldn't even been deemed to be delivered until April 10th. But I don't think the court has to get to that, because normally if he was represented by counsel, you'd have the Cozell factors that the court must go through. Here he's not represented by counsel, so I don't think the Cozell factors apply, because many of those factors are, what was the attorney's involvement, was it the client versus attorney? Clearly here it was the client. However, I think the court still has to outline the prejudice findings of fact, which they did not do. There was no prejudice outlined in the court's orders. There's no findings of fact of prejudice in the order. So I think based on that alone, without having to go beyond that and dig through the record as to notice and things of that nature, I think the findings of fact, the lack of findings of fact as to prejudice alone warrant reversal of the sanctions here. Because while the Cozell factors may not be applicable, I believe that the parts of the Cozell factors that don't apply to attorneys, such as prejudice, would be applicable. And those findings of facts are not made in the order that was signed by the court. However, I do think it's still relevant here that while the court, the entire point of sanctions is not to punish, but to force compliance. And when he was given 10 days to comply, he really wasn't. He was given an hour and 19 minutes pursuant to that order, because the order didn't give him 10 days. It gave him until February 12th at 5 p.m. And based on the record, it was filed with the court and signed by the judge. It was signed by the judge on February 12th and filed with the court February 12th at 3:41 p.m. Presumably, it was emailed to him sometime after that. So when we're looking at, willfulness to comply, and he was given an hour and 19 minutes from this order, and then they basically set a short matters hearing later on where there was, based on the record, it doesn't seem there was any evidence presented. There's no evidence as to willfulness, as to prejudice, and the order doesn't reflect those elements, which I would propose it's required to do. I don't believe sanctions are warranted under those circumstances. Then the error is further compounded by the judge adopting the equitable distribution worksheet and basically saying before it's even filed with the court, the judge says, I am going to adopt all the values that you proposed to me. So here now the judge is passing off their duties to say basically...
Wait a minute, though. There was extensive testimony from the former wife and from the former wife's expert as to the valuations, and weren't there 30 or 40 exhibits introduced?
There were, Your Honor.
So this isn't a situation where there wasn't any evidence. There was only evidence from one side, but the judge accepted that evidence, found it was reasonable, and that your client had forfeited his opportunity to offer evidence.
That's correct, Your Honor. And I would propose first, even if he's defaulted, he still has the opportunity to present evidence as to non-liquidated damages, number one. But number two, the judge also said...
What damages was he looking for?
Well,
here?
damages would be values in this case. What were the values of the property? So while...
He got to cross-examine the witnesses.
He did to some degree, but the judge did put in her order that basically she was accepting their valuations of all assets in this case prior to them even filing the valuations.
Well, I mean, really, the only asset that was of significant dispute was his business, wasn't it?
That was probably one of the largest assets, but there was a number of properties as well. But yes, the value of the business would certainly be the most disputed value.
Counsel, it seemed to me in your brief, although not separated out, as required by the rule, it seemed like you made two arguments here. It seemed like you made the trial court adopted the memorandum, and therefore there wasn't sufficient evidence. But then you also argued that the trial court erred by prejudging the issue, even before the memorandum was filed. Why don't you tell me about that one?
Well, basically, the trial court imposes one of the sanctions, which I don't believe is a proper sanction under the rules, that they were going to adopt.
Well, 12.380B2A seems to suggest that the trial court can accept, and you know, when a discovery order is ignored by a party, right, that the trial court can, as part of a sanction there, accept the facts or the claim of the other party, right? The party obtaining the order.
Correct, but this time the claim wasn't submitted to the court, so the court was blindly accepting the facts at that point, which I would submit
So
to
if
the
the
court as
memorandum
error.
had been already filed, and the court knew what the claim was at the time that the court adopted it, then you would suggest that that wouldn't be error.
I think that would be less error, because here I still believe he has an opportunity to present evidence as to value. He may be defaulted, so to speak, as to how those assets are to be divided up, but he can still present testimony as to quote-unquote damages or what the value is.
Well, all right, walk me through that, because, I mean, it seems like that's the issue here. That's the issue that the discovery went to, right? The equitable distribution, the value of the business things. So how does 12.380B2A, how would that apply if what you're suggesting that your client could still contest the issue?
Well, let me rephrase it. It goes to a default. If someone's defaulted, if you strike your pleadings and someone's defaulted, then that would be, they still have the opportunity to present evidence as to damages. Here, the order said that he was not allowed to testify, was basically allowed to present no evidence. Now, at trial, that's not exactly what occurred.
Well, right now, but the rule says that the trial court, as a sanction, can consider the designated facts as established, right?
Correct. But at the time, the court...
It doesn't say anything about default.
I understand that, but at the time, the court couldn't do that at that time because the facts were not established at that time. So I understand your point. If the facts were established at the point...
If the memo had been filed and the claims had been established in the record, right, then would 12.380B2A, would that apply as a sanction?
It could certainly apply as a sanction. I think it still would be an extreme sanction. I think, you know, if the court basically said that is the sanction that I'm warranting based on the facts of this case, and I find that there's prejudice and there's been numerous willful violations.
At that point, you have to rely. You're on appeal. You would have to rely solely on a lack of prejudice argument, right?
I believe so, but at that point, it could be within the judge's discretion to review the evidence and say, okay, I can see this based on the facts presented in this case. I believe this is reasonable based on the evidence, and I'm going to accept this as the facts and not allow the other side to present any evidence. But that's not what happened here. There was no values presented at the time the court issued the order of sanction in this case. So they were basically blindly allowing them to present any evidence they wanted and basically signing an order saying, submit whatever you want, I'm going to accept it.
I mean, the order acknowledged the memo hadn't been filed yet, right?
Correct. So, and I believe that just further compounds the error here because they were basically allowing the appellee in this matter, the former wife, to write a blank check to herself because there was no evidence before the court. There was no competent substantial evidence.
At the end of the day, though, the judge didn't just blindly accept it. The judge heard extensive testimony and looked at extensive documents. So even if you're correct that there was error, isn't that error harmless since the judge considered all of that evidence?
Well, the judge considered it in the light. There was certainly more evidence presented than the order allowed. But the judge also, my client walked in there basically with this sanction order hanging over his head. And when you look at the evidence presented, you know, there's mathematical errors in the equitable distribution worksheet. We propose that the business valuation is not supported by competent substantial evidence, and the testimony of the expert at that time basically says, this is the best I can do. I don't believe it meets proper criteria for a business valuation. And on the very face of the equitable distribution worksheet, I don't think there's any way around it. There's a blatant math error that cost my client quite a bit of money.
Is that, are you making reference to the loan that she took out or the distribution she took out from the 401k?
Yes, Your Honor.
And the fact that it was, I think it was $28,000 was ascribed to her instead of half less whatever tax consequence there was?
Correct, Your Honor, yes.
Counsel?
Sorry, go ahead. Go. What do you calculate that number at? It was a 71?
I'll have to go back and look at the brief. I believe it was either 28 or 54. I don't remember offhand, but I'll bring that information to you on my time for rebuttal. But I also propose as well with the the tax discount being applied solely to the wife's assets and not the husband's, again, that shows the further compounding of the error here, where basically the judge had made a decision that she was going to accept whatever evidence was presented by the wife. Here, that evidence was supported by documentation and testimony, but I believe that was still error.
Was there any failure to consider the tax consequences other than as it related to the husband's Merrill Lynch account?
I don't believe so, Your Honor. That's the only one I'm aware of. They applied the tax consequences to the 20% discount to the wife's assets, and I believe it was 15% to her pension, but not to the husband's Merrill Lynch account. So unless there's further questions, I'll reserve the rest of the time for rebuttal.
Thank you.
Thank you.
Good morning, counsel.
Good morning, Jennifer Dixon on behalf of the appellee Norma Jean Sumlin. May it please the court.
Can we start in reverse order, and let me ask you about the husband's contention on the Merrill Lynch account. Is he correct that the judge failed to take into account the tax consequence on that as the judge did on the other retirement accounts?
Your Honor, I don't believe that there's an error there, and for what it's worth, that none of these valuation objections and errors were raised below. So those have been waived as not preserved for appeal. It's fundamental from the Cowart case, Florida Supreme Court 1971, that you cannot raise an issue for the first time on appeal. There was a motion for rehearing filed by Mr. DeWitt, and none of the valuation issues that are raised in the brief are raised in the motion for rehearing. If you don't give the trial court...
Laying aside the issue, the preservation issue, on the merits, is he correct that the judge failed to take into account the tax consequence?
I don't believe so, Your Honor. That we had expert testimony that delved into the valuation of these assets, and without any
Well, but the bottom line is, on the wife's accounts, they discounted it by 20% for an assumed tax rate. I don't see how they did a similar calculation on the husband's.
And I don't believe that the accounts are comparable. One was a pension, one is an IRA, or a 401k and an IRA. They're different categories of assets. So they wouldn't be treated...
But the issue still is that they're tax exempt. Now, the valuation of the pension is different. I'm talking about the IRA and the husband's IRA.
And I don't know if the record establishes if these assets are taxed in the same way, if they are pre-tax or post-tax. I don't think that the record establishes it. And this is the issue when you have a litigant who refuses to participate in the process. You know, he was stuck with whatever the former wife brought to the table. The good news is she actually came to the table with evidence and an expert and established the valuations that she was requesting.
Before we go on, in terms of your preservation issue, it looked to me like the 11th paragraph of the motion for reconsideration addressed specific tax valuation issues as it related to 401k IRA. Is your argument just that it's under a different subject header, so it's a different argument as to why?
Well, it was a very, very cursory argument in the motion for rehearing, and they adopted the heading in the brief and then added a bunch of other arguments that weren't raised in the motion for rehearing under that subheading. And so that was the issue with the preservation.
So your argument in the motion is that it's not that it's not preserved, that it's not adequately preserved? Or it should have been preserved in more detail?
The only thing that was preserved with respect to the tax issue, the valuation issue in the motion for rehearing, was 3 paragraphs that talk about the valuation of marital assets, including but not limited to the county bank stock, the Merrill Lynch account, and the former wife's Pontiac Solstice. And that's the extent of the argument. It doesn't say how it's wrong, what's different about it, what the court should have done differently. There's another argument that former husband was entitled to passive appreciation on funds that were withdrawn from the wife's 401k to purchase a home, and for being penalized for having to contribute 20% to the tax of that withdrawal. Those 2 things are in the motion for rehearing. The rest of what's in the brief with respect to valuation is not preserved. And whether the propriety of raising those for the first time in the motion for rehearing is another question that is open. Again, we have a litigant here who refused to participate at the trial, refused to produce one document, refused to show up to hearings that were duly noticed. What was the trial court to do? The trial court actually gave a very fair process, and I think Mr. Dewitt, with all due respect, somewhat overpaints the sanctions that were awarded here. Mr. Sumlin was not barred.
And I apologize for continuing to do this. Judge Orfinger just suggested kind of working backwards. Would you address the accounting issue on the equitable distribution worksheet?
The evidence of the valuation of the assets was uncontroverted. So there's nothing to address other than what was presented by the former wife as valuation. Her valuation is the only one the court had.
The valuation of the distribution that the wife took from the 401K is uncontroverted. Everybody recognizes, I forget what the number was, but everybody agrees on that. What I'm trying to understand is, so the judge says, okay, basically, it was not quite 50-50 marital and non-marital, but basically it was pretty close. So roughly, I think it was like 71,000 was marital, less the 20%, but that's not the number that shows up in the equitable distribution worksheet. It's 28,000 instead of the 54 or 55,000. So even based on that, isn't it just a simple math error that the judge made in that equitable distribution plan?
I don't have the worksheet in front of me to be able to refer to, but even granting that is true, I think that without some kind of controverting evidence or without an opportunity for the trial court.
The evidence isn't uncontroverted. It's just simple math. Everybody agreed that the account was 140, the distribution was like 140,000. And it was basically 50-50, marital and non-marital. And that the wife should have been charged, former wife should have been charged with roughly 71,000, which translated to post-tax about 54, 55,000, but she only got charged with 28. I'm just trying to understand, on that uncontroverted evidence, isn't it just a simple math error?
And I don't know the answer to that, Your Honor. I'm sure trial counsel is watching this on the camera screaming at the screen because she probably has the answer. And I don't know the answer with respect to that math error. What I do know is that if there is a math error, it has to be brought to the attention of the trial court before it comes to this court, and that didn't happen. So it's not for this court to fix that error on appeal. Again, we were dealing with a litigant who would not comport with any of the discovery orders, had 3 chances to try to comply without being sanctioned, and ended up being sanctioned. And the extent of the sanctions was not that he was not allowed to present a case. He was allowed to rebut the former wife's valuations and equitable distribution. He wasn't allowed to put on his own case of equitable distribution, but he was allowed to testify. He was allowed to cross-examine the former wife and her expert, and he didn't make a case for himself. And to stand up, it's actually quite revealing the relief that he's seeking from this court. He's not asking for a mathematical correction. He's not asking for an adjustment with respect to the security interest in his home. He's asking for a remand and a new trial. And the reason he is asking for a new trial is because he didn't participate in the first one, and now he regrets it.
Counsel, what about prejudging, the prejudging issue, adopting your client's memo before it was even filed?
I think there's a terminology issue here. I don't think that the court actually said, I'm going to take all of the valuations that the former wife puts in her pretrial memo as proof. I don't think that that's what the court said. I think what the court said was that that the claims of the former wife would be deemed established by her pretrial memo.
So what's the difference there, counsel?
Well, the valuation still had to be proven, and that's what happened.
What does claim mean if it doesn't, on this issue, what does claim mean then?
Entitlement to division, entitlement to which properties were going to go to whom, that would be more akin to the claims.
Well, the fact that there'd be a division, I mean, there doesn't need to be a court order on that, right? We're in a divorce case, right? There's going to be an equitable division of the property, right?
Well, yes, but sometimes, you divide it not necessarily equally, but equitably, and some assets may go to one party in total, and other assets would go to the other party in total, and it may
But not knowing which asset, so okay, let's take that interpretation of the order. Was it okay to prejudge, essentially give your client a blank check for whatever assets she wanted then?
Well, I don't think that that's what the order did. I think the order said the claims would be
I
established.
thought that's how you interpreted the order.
No, the claims would be established with respect to entitlement to the assets and entitlement to distribution.
So she could say, I want this asset, I want that asset, I want that asset.
And then she had to
then
put
it would
on
be
proof.
It would
of
be
the-
done.
No, I think she still had to go to trial and prove her case. She still had to testify as to
Then what
each-
did the order, I don't want, what was the effect of the trial court's order then? Saying that the claims would be established?
I think it was really a technical order. It was to comply with the rule 12380B. I think it was basically just going through the sanctions that were allowable under that rule, and the court was imposing it. It might have been poorly worded, and it may have been error to prejudge it, but I think it was harmless error in the sense that the valuations that were included in the pretrial memo were established by testimony and evidence and are.
But I guess that's what
substantial
I'm
evidence.
struggling with. If it was a prejudgment, right, if it was, how does presenting evidence resolve a prejudgment? How is that not just saying, here, judge, here's my blank check, rubber stamp it?
Because there was no order. There was no final judgment that adopted the pretrial order as is. There was a trial that happened. There was an interim event, and there was a trial where those
Which claims did your client make that the trial court did not rule in your client's favor?
I think she got everything in her favor. I mean, there was
I thought so,
nothing.
too.
There was nothing to oppose.
I thought so too. So how does that, again, if there was a prejudgment, right? Help me out here. Help me out. So we went through this big trial with a whole bunch of evidence. Your client got everything. You have this order that looks like a prejudgment. Help me out. Help me understand how all the evidence that was presented solves the prejudgment, if there was one.
Because at the end of the day, the final judgment has to be supported by competent substantial evidence.
Isn't that a different issue than prejudging the issues?
There has to be prejudice with a prejudgment, Your Honor. I just don't think that, by saying I'm going to prejudge it without a result, that there's any prejudice to the former husband by having her done that. And that's the one thing about the sanctions that Mr. DeWitt argued that there had to be some showing of prejudice to impose the sanctions. I don't think that's correct. I think the standard is what was the prejudice to the husband by having the sanctions imposed? What would have been different had he not had sanctions imposed against him? What would he have brought to trial? Who would he have had testify? What would he have said? I think that we know the answer based on the track record and the record below. He wouldn't have done anything. Nothing would have been different if the court hadn't
Are you
imposed
suggesting
sanctions.
that the appellant would not have presented any case in chief?
I am suggesting that. I think the record
Well,
supports that.
counsel, I'm not sure we can know that from this record.
I think the trial judge could have, and I think the trial judge was in the best position to weigh the credibility and the plausibility of the witnesses.
So the trial judge says, appellant, you may not present evidence, and the appellant doesn't present evidence, and now we're going to say the record established that he would not have presented evidence under any circumstance.
But the court didn't say you can't present evidence. He said you can't put on a case in chief as to equitable distribution. He was not prohibited from putting on a case in chief with respect to attorney's fees, with respect to whether.
No, obviously, I was talking about equitable distribution.
Sure.
Right.
So how many chances do you get to participate in the process?
No, counsel, we're talking about, you said that the record demonstrates conclusively, I think that's how I interpreted what you're saying, that appellant would not have presented any evidence in a case in chief. And I'm challenging that statement. I don't understand how the record could possibly establish that.
I'll cite to page 744 of the record where the former husband testified. This was during his opening statement at trial. He excused his noncompliance with discovery by saying he didn't have time. So I don't know how he was going to have more time if he didn't have sanctions imposed against him. He said, I guess I could have been responding back and forth. I don't have the time. I get up at 3:30, 4 o'clock in the morning because, again, I'm my own brand.
Counsel, but do you acknowledge that you're making at least somewhat of a leap there?
Well, I think that obviously the credibility and demeanor of the witnesses is for the purview of the trial court. It's not for us to stand here at the appellate level.
I'm not talking about the credibility and demeanor. I'm talking about just putting on evidence in a case in chief.
Well, not
Maybe
one
that would
document.
not have been credible, right? Maybe it wouldn't have been credible. I'm not saying that is really not relevant to what I'm asking you.
I just disagree that it's a huge leap, knowing that he had as many opportunities as he had to present documents in response to discovery and didn't do it, knowing that the ultimate sanction was he was going to be barred from participating at trial. If that's your, if that didn't motivate him to participate.
If the trial court prejudged,
That didn't
equitable-
happen until April.
if the trial court prejudged equitable distribution, if we conclude that the trial court did prejudge it before the memo was even filed, so before the claims were on the record, then explain to me again why it's not reversible. We'll start with this. Does 12.380 allow for that?
12.380 does allow for the court to
To establish claims that haven't been filed?
No, I'm sorry, I misunderstood your question. I thought you were talking about the prejudgment issue with the equitable distribution.
That's what I'm asking.
Worksheet.
The memo hadn't been filed yet.
Correct.
If the trial court's order made the prejudgment that whatever the memo says we're going to accept as established,
The petition
that
asked
permissible?
for the distribution of assets. It wasn't reserved for the pretrial memo. The assets were identified previously.
I understand that. Okay. But the memo wasn't filed yet, right? The claims
Correct.
in the memo weren't filed.
Correct.
The trial court, if the trial court prejudged and accepted the memo as established before it was filed, is that error?
I don't believe that's error because I believe that is allowed by the rule, 12.380B. But
So your position is the rule doesn't require that the claims be on the record yet? The
I
trial
think
court
we're
can establish
mixing-
claims that aren't on the record?
I think we're mixing the term claims. The court used the word claims in the order, but the claims were presented in the petition for dissolution of marriage. So to the extent,
Well, the rule uses the word claim.
claims can be, claims that are pled, obviously, can be deemed admitted for the purposes
The trial court didn't point to the pleadings. The trial court pointed to the memo, right?
That's correct.
Which wasn't filed yet.
It could be semantics, yes, that might have been, and that might have been error. But again, Your Honor, I think that that is harmless error at worst. Because again, there was nothing in the final judgment that adopted the former wife's pretrial memo without the benefit of substantial competent evidence in the record. So the other issue is that argument was not preserved. So it was not objected to. The husband didn't object to it at trial, the use of the former wife's pretrial memo. It's not exactly accurate the way it's asserted in the initial brief. And again, so the valuations being supported by testimony and evidence, I think, takes any error away from that and turns it into a harmless error for purposes of appeal.
I wanted to clarify something in your brief that I'm not sure I understood as it related to the homestead issue. Is it your client's contention that she cannot force a sale of that house, or that she would not force a sale of that house?
There's case law that goes back to the Florida Supreme Court in
Just asking for your client's position.
Yeah, no, it is her position that it's within the husband's realm to make sure that the forced sale isn't necessary because it's an installment agreement. He had 12 months to pay the $32,000 that he was required to pay, which consisted of attorney's fees and
The question was, if he signed the mortgage, that it's not in the record, so we don't know what the mortgage says, but assuming it's a standard mortgage, if the husband defaulted on his installment obligation, would the wife have the ability to foreclose on that property?
yes, Your Honor.
Okay, and is that problematic if the property is in fact the husband's homestead?
It is not problematic because Roth versus Roth, which is cited by the former husband in his initial brief, states that even if this were not a mortgage lien and as a pure equitable lien, which the courts have said is a forced sale under the
Well,
Constitution.
but the equitable liens only apply when you have fraudulent or improper conduct.
Agreed.
And this isn't, there's nothing fraudulent or improper. This is just a garden variety divorce.
I think Sell versus Sell would lead to a conclusion that this contemptuous conduct arises to the level where an equitable lien would be allowable, but that's not what the situation we have.
We might have a difference of opinion on that, but
Again-
be that as it may, if it's his homestead, what's your best argument for the fact that you can attach it, make him sign a mortgage? First of all, what's your authority to force him to sign a mortgage at all?
That would be
And
61075.
number two, how can you force a sale on it if it's his homestead? Unless you, is your argument that it's got to be the equitable misconduct kind of exception?
No, Your Honor. 61075 allows the court to do equitable distribution in installments.
Well, you don't suggest that the statute trumps the Constitution's protection of homestead?
No, Your Honor, but the Constitution specifically specifically states that a homeowner can divest himself of property through a mortgage,
Well, but
which is
that-
why
that-
the mortgage
that
is
be voluntarily,
It's a
right?
voluntary act.
Is this voluntary?
Well, it is, because if he wanted to just pay the $32,000, he
Signing the
doesn't have to
mortgage?
sign
No,
it.
no, no, no. Signing the mortgage, is that voluntary?
I mean, he's not agreeing to do it, right?
Well, he hasn't done it, so no, I guess it's not
Pay
voluntary.
us a whole bunch of money or sign it, that makes it voluntary?
Well, yes, he had the opportunity to pay the lump sum, and she gave him the opportunity to pay it in payments. The statute says she can award a security. I'm sorry, I'm out of time.
Thank you, counsel.
Thank you.
Let's again start backwards. Talk to me about preservation of two specific issues. What we've called the math error on the wife's distribution of the 401k plan, and I'm having a brain freeze here. The tax issue on the Merrill Lynch account.
So the tax issue, I believe, was raised in the motion for rehearing. And I believe there's a general statement in the motion for rehearing that the evidence presented by the wife was not supported by competent substantial evidence, which I think is where the math error would arise. And just to get back to Judge Traver's question from before, it was a $134,000 withdrawal from the 401k, 53.6% was marital, so it should have listed either $71,824 without the tax, or if there was a tax, $57,459, which would make it either a $28,729 error or a $43,094 error.
Doesn't that leave the trial court in this impossible position, right, when you have a general statement that's that general? It's, hey, Judge, it's not supported by substantial competent evidence. Good luck figuring out how, why, and where, right?
Well, I certainly understand that, the concern there, but we did go through and say, the equitable distribution worksheet was not supported by competent substantial evidence. And in our opinion, there was numerous items in that equitable distribution worksheet that was not. So at that point, of course, it is
Why
always...
not list those out for the trial court to give the trial judge a fair opportunity to correct it, right?
Well, if you want the realistic answer, he was a pro se individual, and we didn't have the knowledge of the specifics at that time, and we did the best we could based on the limited time frame that we had to get everything before the trial court from a realistic standpoint. Obviously, we're not in the business and certainly don't want to be putting judges in a position of the gotcha. That's the whole point of the motion for rehearing. Here, obviously, it was denied without a further hearing where maybe we could have presented more detailed evidence and brought in witnesses if necessary to establish those errors further. But here it was obviously a blanket denial. We didn't get that opportunity to do that further. Also, I'd like to address the counsel's point that it was our burden to establish the prejudice. I really don't think that's what the case law says. Citing to the Celebrity Cruise case out of the 3rd, which is cited in our brief, that case does say, thus, where a trial court fails to make express written findings of fact to support a conclusion that a party's failure to obey court orders demonstrates willful or deliberate disregard, the dismissal of such action or striking of a party's pleading constitutes an abuse of discretion. Here, I believe the court really was required to at least outline the willful and disobedient conduct as well as prejudice to show that the wife would be somehow prejudiced in this matter. Again, they didn't take any depositions. They did do third-party subpoenas. They had other ways to get a lot of this information going forward. And even regardless of that, the order just doesn't make those findings of facts, which I believe it was required to do. So based on that alone, based on the lack of findings of fact of prejudice, I think the court could reverse the sanctions there. I think it's certainly speculative, a further statement that the husband wouldn't put on a case. He did show up to the trial. It's not like he didn't show up to the trial at all. And as far as the prejudgment of the issues on the equitable distribution worksheet, typically a default, and I'm going kind of outside the scope of this case here, but a default only admits well-pled allegations. And so essentially what the court did here was, what I stated earlier, was these allegations were not well-pled, the values were not in front of the court. They rubber-stamped it and said, hey, we're going to accept whatever valuations you present. And that alone, I believe, is error that should be reversed by the court. Unless there's any further questions, I'll...
All right, thank you. Any
Thank you.
further questions? All right, thank you. We'll take a short break and